Good afternoon and welcome to today's webinar, Addressing the Impacts of Climate Change Through Law and Policy, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this webinar will be available on our website shortly after the conclusion of this event. We strongly encourage attendee participation and would love to hear some of the thoughts and questions that you have, so feel free to submit them at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send us your question. Your moderator for today's webinar is Jill Kruger. Jill is the Director of the Network for Public Health Law's Northern Region Office, where she provides legal technical assistance on a variety of health topics. She specializes in building relationships and fostering connections among public health leaders across the country and creating practical legal tools and trainings to assist practitioners, attorneys, and advocates in crafting public health solutions. Her current work focuses on mental health, rural health, climate resilience, agricultural and food law, and oral health. Jill will be leading us through the rest of today's webinar. So Jill, over to you.
Thank you, Charles, and hello everyone, and thank you for attending today's webinar. As Charles mentioned, I'm Jill Krieger, and I'm the Director of the Northern Region of the Network for Public Health Law. And I am really pleased to serve as the moderator for today's webinar. Our presenters have prepared some excellent content, including some really fabulous resources and tools that you can use to address the health impacts of climate change through law and policy. So without further ado, I'll introduce our three presenters and then hand things over to Dr. DeJarnette. Dr. Natasha DeJarnette is the Research Coordinator at the National Environmental Health Association, where she leads research as well as children's environmental health activities. She completed her PhD and Masters of Public Health, both concentrating in environmental health sciences, and was named 2017 Alumna of the Year for the University of Louisville School of Public Health and Information Sciences. Prior to NEHA, she was a policy analyst at the American Public Health Association, where she led the Natural Environment Portfolio. Rob Kroll joined the Great Lakes Indian Fish and Wildlife Commission in June of 2018 as a policy analyst in the Division of Intergovernmental Affairs. His duties include coordination of GLIFWC's climate change program and providing policy analysis and operational experience to the Enforcement Division. Prior to GLIFWC, Rob served for 18 years as a Waterways Conservation Officer with the Pennsylvania Fish and Boat Commission, specializing in environmental enforcement and natural resources criminal investigations. Our third speaker, Justin Gundlach, is an attorney at the Institute for Policy Integrity at the NYU School of Law. His work focuses on state-level energy and climate policy. He is the co-editor of Climate Change, Public Health, and the Law from Cambridge University Press, and the author of numerous articles, book chapters, white papers, and amicus briefs on legal and policy issues related to the impacts of energy use on climate and of climate change on infrastructure and public health. Without further ado, I'll hand things over to you, Natasha.
Thank you, Jill, and thank you to the Network for Public Health Law and the organizers. It's an honor to speak with you today, and I look forward to sharing with you about the health impacts of climate change. Before I delve into the many ways climate change harms health, I'd like to tell you about the National Environmental Health Association, also known as NEHA. Our mission is to advance the environmental health professional for the purpose of providing a healthful environment for all. As I'm sure you're very familiar, environmental health professionals make up the second largest segment of the public health workforce, ensuring that we have clean air to breathe, safe water to drink, safe food to eat, and are protected from disease-carrying vectors and public health pests. We have over 6,000 members who are predominantly from the public sector, working at all levels of government, including federal, state, local, and uniformed services, but also including professionals from academia and industry. We have a long, successful history of providing training as well as being a resource within the environmental health community. Our members work in many areas that are both directly and indirectly related to climate change. Government Affairs at NEHA advocates on behalf of the environmental health workforce. NEHA's solution to environmental health challenges like climate change is to invest in credentialed environmental health professionals in the workforce. As such, we have helped secure funding for Zika, CDC's Climate and Health Program, and hurricane recovery from the 2017 storms. We also work to ensure that the voice and expertise of environmental health professionals was reflected in the Pandemic and All Hazard Preparedness Act, which was signed into law this year. This puts environmental health professionals at the table to ensure that every community is prepared for environmental hazards in the event of disasters, which are unfortunately becoming all too common with climate change. With funds from CDC, we provided support to the climate and health adaptation activities in the Minnesota Department of Health and a tri-county region in the Portland, Oregon metropolitan area, including Clackamas, Washington, and Multnomah counties. With funding from Eco-America, this has allowed us to do work to inform policy. We have developed a report on climate change and emergency preparedness, highlighting the environmental health role. With Eco-America, we published the results of 3 years of the American Climate Metrics Survey this April in the Journal of Environmental Health, and this survey was conducted on our membership. Eco-America has hosted a climate ambassador training for the past 2 years during our annual educational conference. And in addition, I am proud to announce that our board unanimously declared that by 2030, NEHA will be 100% clean energy. Lastly, our members are quite engaged in climate and health as well. We have a Climate and Health Program Committee. And along with this committee, we currently have a policy statement on climate change. This statement is up for revision and will be updated and resubmitted this fall, along with a new policy statement on renewable energy. I will now briefly step through the many ways that climate change impacts health. We all deserve clean air to breathe, and climate change is decreasing the quality of the air we breathe. It's increasing carbon dioxide levels in the atmosphere, trapping heat and pollutants below, like a blanket traps heat. Air pollution decreases our air quality, and so also does heat. Climate change makes conditions suitable for drought, which is conducive to wildfires. The smoke from wildfires also reduces our air quality. The longer, hotter, warm season is resulting in a longer pollen season, and research suggests that increased carbon dioxide is also increasing the intensity of pollen. So we have a longer and more intense pollen season. Another key allergen affected by climate change is mold, which can result after flooding in our homes, schools, and workplaces. Poor air quality is associated with increased risk of heart and lung diseases. As I shared, it's increasing the length and intensity of pollen season, which is bad news for allergy sufferers. And this is more than just a nuisance. Both allergy and asthma increase the likelihood of increased or decreased productivity and even absences from school and work. The Harvard 6 Cities study shown here on the left demonstrated that cities with higher pollution levels also have higher mortality rates. And on the right, Dr. Arden Pope and others found a significant positive association between air pollution reduction and increased life expectancies. But on the other hand, higher pollution is therefore associated with shorter life expectancies. This figure here is from Dr. Robert Brook and others, and they found that air pollution increases risk of cardiovascular disease mortality, When compared against all-cause mortality and cardiopulmonary disease, cardiovascular disease significantly increased mortality across multiple studies that were assessed, increasing risk from 5 up to 15%. This figure shows evidence that the increased length of pollen season, evidence of the increased length of pollen season, particularly you'll note in the upper Midwestern areas of the U.S. In the 2016 U.S. Climate and Health Assessment, the U.S. Global Change Research Program reported that climate change has increased in frequency and intensity of extreme heat events. This is especially concerning because heat is the top cause of natural weather-related deaths nationwide. Exposure to extreme heat can increase the risk of dehydration and heat-related illness, including heat exhaustion, heat stress, and heat stroke. Also, heat stroke can be deadly if not treated quickly. Exposure to extreme heat also increases the risk of complications from respiratory diseases like asthma, as well as cardiovascular disease. This figure examines heat deaths during the 1995 Chicago heat wave. The green line represents temperatures. The orange line is the average daily deaths between 1990 and 2000, and the dark red line represents the daily deaths from 1995. And you can see that when the temperatures spiked during the heat wave, which is the blue area on the graph, so too did the number of deaths. This study from the state of Maryland demonstrates that extreme heat is also associated with increased hospitalization for asthmatics. And unfortunately, the outlook is not good if trends continue. In the fourth National Climate Assessment, researchers estimated that continued temperature increases may increase mortality risk. In the lower scenario, resulting in an additional 3,900 deaths per year, and an additional 9,300 deaths per year in the higher scenario, shown there on the right. Increased carbon dioxide in the atmosphere is increasing surface temperatures of waters, making the occurrence of extreme weather events more frequent and more extreme. 2017 was a record-breaking year for hurricanes, with Hurricane Harvey, Irma, and Maria all making landfall on the U.S. These photos spotlight some of Hurricane Harvey's victims. And I want to put a spotlight on children. Children are especially susceptible in extreme weather because they rely on adults to make decision-making and for care of them. They're not able to make decisions to protect their health and safety. For children and adults, the impacts of extreme weather not only threatens physical health, but mental health and well-being, which I will cover a little bit later in this talk. The figure here demonstrates that hospitals aren't immune to the threat of climate change. You can see the hospitals in the coastal communities in the U.S. are susceptible to flooding, even by lower category storms. Ultimately, our infrastructure is unprepared for the health threats of extreme weather. Extreme weather can disrupt our access to services. Bridges and roadways can be swept away. In these scenarios, emergency service providers, like ambulances, for example, can't access the people that need them. They're not able to get to the hospital, and this may be when they need it the most. The impacts of extreme weather are costly on human health, but also on the economy. The graph here shows the number of deaths estimated from extreme events that had losses exceeding 1 billion. 58 extreme events were included from 2004 through 2013. Very unfortunately, climate change, if unaltered, will increase the frequency and intensity as well as the geographic distribution of these events, which will continue to impact our health and economy. Heavy precipitation events have increased in intensity and severity as well, and we're experiencing extremes in precipitation, both flooding and drought. Floodwaters can overflow our sewer system, sending untreated sewer water directly into our drinking water supply. This increases our risk of gastrointestinal illness. One study demonstrated that about half of all waterborne disease outbreaks were preceded by an extreme rainfall event. Flooding destructs our communities, putting us at risk of injury and death. Displacement causes us to lose our community ties, impacting our mental health. And I've already mentioned to you the infrastructure damage that can result, affecting our roadways and access to needed services. Drought, on the other hand, causes adverse impacts on the agricultural sector. It decreases crop yield, contributing to food insecurity and malnutrition. And as I shared before, drought also creates environments conducive to wildfires, increasing our risk of smoke exposure, raising our risk of heart and lung complications. This map shows the projected percent increase in weeks of very large fires by mid-century. The darkest shades of red indicate that up to a six-fold increased risk is projected. Please note the large increase along the southern coastline and the Great Lakes that once did not have this level of vulnerability. This figure demonstrates drought may increase crop yields for barley, maize, rice, and wheat. And not only does climate change decrease crop yields, it also may decrease the nutrient quality of crops. Researchers from the 2016 U.S. Climate and Health Assessment found that as carbon dioxide levels increase, protein in flour decreases. And also, under high levels of carbon dioxide, concentration for most minerals, including a stronger association with zinc and iron demonstrated with other studies. This is another way that climate change contributes to malnutrition. Climate change increases the amount and geographic distribution of disease-carrying mosquitoes and insects, otherwise known as vectors. Consider Lyme disease. About 2 decades ago, Maine reported about a dozen cases of Lyme disease. And in 2018, Maine had reported 1,500 cases of Lyme disease by mid-summer. And then also consider Zika. The spread of Zika can also be associated with climate change, and especially concerning because of microencephaly that can result. Researchers from the 2016 U.S. Climate and Health Assessment demonstrate the expanded prevalence and distribution of Lyme disease predominantly in the Northeast and Upper Midwest. Also from the U.S. Global Change Research Program, they examined West Nile virus over 4 years. And I repeat, in just 4 years, they were able to demonstrate increased incidence of West Nile virus, especially throughout the central and western United States. Climate change not only threatens our physical health, but our mental health as well. Exposure to extreme weather and floods can increase risk of stress, anxiety, post-traumatic stress disorder, and depression. Nearly half of Hurricane Katrina survivors developed a mood or anxiety disorder, and 1 in 6 developed post-traumatic stress disorder. Extreme heat or extreme weather can increase the risk of depression, violence, suicide, and suicidal ideation. Extreme heat can render inactive some psychotropic medications. Also, droughts and extreme heat can also be a source of conflict, especially internationally. We're all at risk to the health threats of climate change. And I've demonstrated today that the health threats are vast, but some groups are more vulnerable to these health threats, and climate change can actually be a threat multiplier for them, exacerbating some of the inequities that these groups already experience. For example, air quality can adversely affect our African American communities and Hispanic and Latino communities because they're more likely to be on the front line of polluting industries. People that are chronically ill and elderly are also more susceptible. With extreme heat, those that live in an urban heat island are especially at risk, where temperatures in an urban heat island can be 23 degrees higher at night compared with the cooler surrounding areas. Outdoor workers are also especially vulnerable when it comes to extreme heat, along with children and the elderly or folks that are otherwise socially isolated. Extreme weather can leave our children and elderly, our disabled populations and communities of color, and those that live in communities that lack resources or infrastructure. They can be more susceptible in extreme weather. In extreme precipitation, children, elderly, disabled are susceptible, but I'd like to put a little emphasis on outdoor workers or communities that have close ties to the land, like tribal or indigenous communities, those whose livelihood relies on agriculture, or those whose cultures are closely connected to the land. And then with vector-borne disease, pregnant women and children are particularly susceptible, along with communities that lack resources, including impoverished areas. But I offer you the environmental health workforce as a powerful solution as we are facing climate change. Many in the environmental health workforce work in the area of climate and health adaptation, and as we work to adapt to the health impacts of climate change, environmental health workforce contributes by testing air and water and soil quality, disseminating alerts on air quality, extreme heat, and extreme weather, enforcing air quality regulations, educating physicians and care providers, as well as community organizations, and also direct education to the communities about the health threats and how to keep themselves safe. We also want to ensure access to interventions that protect health, including cooling centers, ensuring safe evacuation access, and issuing water advisories when there are water contamination concerns. And then also a large segment of the environmental health workforce works in vector-borne disease. Within NEHA, that is our second largest specialty within our membership. So vector control is especially important as we're working to adapt to the current health impacts of climate change, and certainly looking to eradicate the areas that are vector prone, like areas with standing water. And there's also much more that can be done through strong and vital partnerships. NEHA is proud to endorse the U.S. Call to Action on Climate, Health, and Equity. This builds on the 2018 Global Call to Action on Climate, Health, and Equity. And the themes include that climate change is a health emergency. It's urgent and it's happening now. That we collectively are dedicated to improving health of our communities. That actions on climate change can dramatically improve health, but equity must be central to this action. So with the right policies and investments, we have the opportunity to realize our collective vision of healthy people in a healthy planet, in healthy places on a healthy planet. So I encourage you to visit climatehealthaction.org to learn more about the call to action, and you'll have the opportunity to sign up your organization there as well. With that, I thank you for your time. I look forward to your questions during the question and answer portion, and I look forward to hearing from the other presenters. Thank you.
Thank you, Natasha. Uju Niji Bimadazig, Rob Indigenous, Gaween Indo-Demosine, Philadelphia Indunjaba, Cliffwick Indanoki. My name is Rob Kroll. I'm the Climate Change Program Coordinator for the Great Lakes Indian Fish and Wildlife Commission. We are a tribal organization under Public Law 93-638. We exercise authority delegated by our 11-member Lake Superior Ojibwe tribes to implement federal court orders and interjurisdictional agreements related to their treaty rights. I myself am not Ojibwe. I introduced myself in the language for a number of reasons, but a couple of them are one of our missions at Glyphwick is to integrate Ojibwe culture into everything that we do. And for me, it's also a reminder that I work for the tribes and not for myself. So some of the way we assist our member tribes is in securing and implementing their treaty guaranteed rights to hunt, fish, and gather in the Chippewa treaty ceded territories in Michigan, Wisconsin, and Minnesota. We work off reservation. The tribes themselves have complete sovereignty over natural resources on their reservations. We assist them with their co-management of resources off reservation as reaffirmed for them in a series of court cases that I'll get into in a minute. So we're talking about treaty reserved rights. And what that means essentially is that these are rights that predate the forming of the United States of America. These are rights that indigenous people always had. And the ancestors of today's Lake Superior Ojibwe had the foresight to reserve these rights in the treaties that they negotiated with the United States. There were a series of treaties negotiated in the mid-1800s. All of them included an article such as the one you see here on the screen, reserving the rights to hunt, fish, and gather in the treaties ceded to the United States in the treaties. Shortly after the 1854 treaty was ratified by Congress, the states of Wisconsin, Michigan, and Minnesota were admitted to the Union. And based on the equal footing doctrine, the states began enforcing fish and game laws and fining and jailing Ojibwe people for exercising the rights they believed had been granted to them in their treaties. These rights, however, were reaffirmed in a series of state and federal court cases in the late 20th century. This is some simplified treaty interpretation from the Mille Lacs versus Minnesota case. Treaties are to be interpreted based on the way they were understood by the tribes who negotiated them. Courts are to construe treaties liberally in the tribe's favor. The tribes at the time did not speak the language, they did not write the document. So the idea is to interpret treaties based on how the tribes at the time would have believed them to have been written. So in Mille Lacs, it was found that neither Congress nor the President have expressly terminated the treaty rights. Statehood also did not terminate those rights. The misbehaving interpretation refers to sections in some of the treaties, such as the pleasure of the President, or another treaty states that they will continue to have their rights as long as they behave themselves well. So tribes had always interpreted the treaties to say that they retained their rights as long as they lived in peace with their neighbors, and that includes other tribes as well as European Americans. And I should note here that these treaties are specific to the 11 Lake Superior Ojibwe tribes. Not all tribes have treaties. Ones that do may not have reserved rights, such as the Ojibwe reserved for themselves. And this differs tribe by tribe across the country. So the court reaffirmed rights include the right to continue the traditional hunting, fishing, and gathering way of life in all parts of the ceded territory, and not just on their reservations. The right to virtually all of the natural resources found in the ceded territory, and the tribes are entitled to a maximum of 50% allocation of harvestable resources. Treaty rights are tribal rights. So they're retained by the tribes as sovereigns and not by each individual member, which also gives the tribes regulatory authority off reservation over tribal members exercising their rights. And tribes are required to co-manage ceded territory resources with other sovereigns. So that would be the states and the federal government. And the Glifwick member tribes created the agency to do just that, not on their behalf, but to assist them with this management. So to do that, we provide support including scientific natural resources management, conservation enforcement, policy analysis, and communications and outreach. The folks you see at the bottom of the screen are harvesting wild rice. This is probably not an activity that people in other parts of the country would be familiar with. Wild rice, or manoomin, is a central resource for the Lake Superior Ojibwe. It's central to their concept of themselves as Ojibwe people. Wild rice is the basis for their migration story. Their ancestors migrated from somewhere on the East Coast to the Great Lakes several hundred to 1,000 years ago. And by prophecy, they were meant to go to the place where food grows on the water. That food is manoomin, or northern wild rice. And the ability to harvest and use manoomin is central to what it means to be Ojibwe. It's the first food that many Ojibwe children eat for solid food, and it's often the last food that elders have in their last meal before they walk on. Wild rice has a very low glycemic index. It's a complex carb, but it's also high in protein. It supplies a number of micronutrients, and it stores indefinitely after processing, which means it's the perfect food to get people through a long, harsh North Country winter. So how do treaty rights fit as public health law? The CDC has determined Native Americans have a greater chance of having type 2 diabetes than any other U.S. racial group. They've also determined that access to traditional foods and traditional harvesting activities are an important component of programs to help natives prevent or control diabetes, along with heart disease, stroke, and other public health risks. Food sovereignty is considered tribal sovereignty. And in our specific case here, most manoomin waters used by the Lake Superior Ojibwe tribal members are off reservation in the ceded territories. So Glifwick is working on finishing up a climate change vulnerability assessment in which we look at the climate vulnerability of 60 different culturally important fish, wildlife, and plant beings as selected by tribal members, harvesters and gatherers, and also based on historic and current cultural use. And manoomin, or wild rice, is the most vulnerable of those beings in our vulnerability assessment. Some of the other ones include orboos, which is snowshoe hare, moose, northern white cedar, walleye, paper birch, sugar maple, Barry's berries, moose, and Wawaskeshi, or white-tailed deer. Some of the factors that make wild rice particularly vulnerable to climate change include natural barriers to being spread. Lake Superior and upland habitats prevent that. It typically grows in a specific environment, shallow muck bottom waters. It likes a limited thermal niche. It requires really cold water, really low oxygenated water to be able to germinate in the spring. It's a perennial plant. It has a specific hydrological niche, and it's very vulnerable to flooding, which is one of the climate change impacts we expect up here in the Great Lakes region. It is dependent on a particular disturbance regime, but it can't be too disturbed. It's very vulnerable to several pathogens and also to competition from invasive. There's very little genetic variation, and we are already seeing a documented response to climate change based on our vulnerability assessment. So this is kind of how climate change is seen in Indian country. It's an existential threat to an already threatened way of life. In speaking with various tribal hunters and gatherers, tribal members, what they tell us is a lot of their traditional knowledge is at risk, particularly things like indicator species, which tell them when it's time to hunt, fish, gather, do a particular cultural activity. And because of climate change, those things are changing. A lot of their resources that they've depended on for time immemorial, including wild rice, potentially could be extirpated in the ceded territories on their reservations. And treaty rights and the ability to hunt, fish, and gather based on those rights are limited to ceded territories. So they're based in place. Now I'd like to talk about a tool that was recently released by Glyphwick and a number of our partners to help indigenize climate change adaptation, particularly for natural resources, but also cultural resources, infrastructure, things like that. These are some of our partner agencies: 1854 Treaty Authority, which is another intertribal organization; College of Menominee Nation Sustainable Development Institute; Northeast Climate Adaptation Science Center; Northern Institute of Applied Climate Science; the Intertribal Council of Michigan, the U.S. Forest Service, and several of our Glyphwick tribes, particularly the Lac du Flambeau Band of Lake Superior, Ojibwe. So our Tribal Climate Adaptation Menu is based on the Climate Change Response Framework developed by one of our partners, the Northern Institute of Applied Climate Science. They've created an adaptation workbook process, which is a structured process which integrates climate change into considerations into natural resource management. Basically, their process allows the user to assess their management actions in light of specific climate change impacts in their area, and then design a custom set of climate change adaptation actions based on both their goals and the impacts they're expecting. There are a number of different adaptation menus that NIAX created, including the forest menu and the wetland menu. Our Tribal Climate Adaptation Menu is part of that framework. However, it's also a standalone resource. These are some of the basic values and perceptions that we tried very hard to incorporate into the menu. Respect both for other people but also for the natural environment. Reciprocity, which in the worldview of the Lake Superior Ojibwe, natural resources really aren't a thing. It's a reciprocal relationship between humans and their non-human counterparts in the world. Relationships, elders, stories, language, and then acknowledgement of and respect for the historical and intergenerational trauma that is still going on in Native communities today. The menu contains a guiding principles document. which describes detailed considerations for working in tribal communities. It discusses things such as the importance of human and non-human relationships, different cultural paradigms between indigenous and Eurocentric communities, how to engage the Native communities and community consensus decision making, how to end a project and disseminate that information. All too often in the past, academic institutions and others have come into Native communities, done research, and then never shared any of that with the communities. This version is written from an Anishinaabe or Ojibwe perspective, along with Menominee, which is our neighbors up here in Wisconsin. But it's designed to be adapted to other indigenous peoples through incorporation of their language, culture, and perspective. The menu itself is designed for use by tribal communities and their non-tribal partners. It uses a strategy, approach, tactic framework. The first three strategies address cultural practices, community engagement, and recognizing that human-non-human reciprocal relationship. It also emphasizes that sometimes not doing something may be more important than rushing headlong into an action that hasn't been fully considered. In traditional natural resource management, we use a stringent top-down adaptation process, and this process that we have created in the menu allows for a more holistic view. So if you're at all familiar with natural resource climate adaptation, some of the strategies and tactics will look very familiar, such as control of invasive species. Others are tailored to concepts contained in Anishinaabe and Menominee language and worldviews and promote traditional lifeways. We recognize that revitalization of language and culture are important components of climate adaptation in indigenous communities. And this is a truly cross-sectoral menu. It's been used to plan forestry, fisheries, wildlife, wetland, and infrastructure adaptation projects. Finally, I'd like to mention one real-world project of several that have already been created using the menu. The Spur Lake State Natural Area is a small lake in north central Wisconsin. It traditionally had a significant wild rice harvest on it. Several reservations in the area have strong history of gathering wild rice there. It's now owned by the Wisconsin Department of Natural Resources. And their goals for this area to promote the reestablishment of wild rice and also to maintain a shallow muck bottom lake for wildlife resources. Wild rice, which I should have mentioned earlier, is a very important foodstuff for waterfowl, particularly on their migration, along with people. So the climate challenges in this case are increased water levels, which flood out the wild rice in its floating leaf stage when it's particularly vulnerable. There are current issues with invasive species, including several species of cattail, and potential future invasives based on analysis of climate change impacts. And there's some altered water quality issues. Partners in this endeavor included the Wisconsin DNR, the Sakaagan and Lac du Flambeau Ojibwe communities, Glifwick, and the Northern Institute of Applied Climate Science. And it actually used two of the menu products, the Tribal Adaptation Menu and also the NIAX Wetlands Menu, to come up with this series of adaptation tactics. From the Tribal Adaptation Menu, gathering traditional ecological knowledge from local tribes to better understand the lake and its history, and to understand historical rice camps and past harvests. And then there are several on-the-ground adaptation actions that came from the Wetlands Menu, all of which are also contained in the Tribal Adaptation Menu and could easily have come from there. Finally, I'd like to say miigwech on behalf of my climate change program and also our author team. Thank you for listening. Look forward to your questions. And I'll be passing off the ball to our next presenter.
Thanks, Rob. This is Justin Gunlock of the Institute for Policy Integrity. I should start off also by thanking Jill and the Network for Public Health Law for the invitation to present today. Rob just gave you a focused discussion of a particular issue. I am going to zoom out and try to talk about the whole thing. That is, I'm going to talk about Climate Change, Public Health, and the Law, which is a book that I co-edited along with Mike Berger, the Executive Director of the Sabin Center for Climate Change Law at Columbia Law School. So to begin, quick background about the book. Mike and I looked and noted a clear gap in the literature. There was lots that had been written about climate and public health, and there was lots that had been written about climate and the law, but no one had brought all three together. And it was our sense that given what was needed seemed to be the information about how to implement this combination was one that we thought would be worth a book, or maybe several. And so we recruited experts from legal academia and elsewhere, including Jill, to write our chapters. And in order to organize what was a sprawling and unwieldy topic, we vied with several different frames, so mechanisms that give rise to climate impacts, public health problems and solutions, and legal authorities and their limits. And what we came up with was, well, you'll see what we came up with in my quick overview of the sections of the book and how the chapters are laid out. One last point to note, while I've got you looking at the cover, is that the paperback version is now available through Cambridge University Press. Unlike the hardback, the paperback is not priced astronomically, so do consider it. So the organization of the book is in 4 parts. Here are the first 2. We wanted it to offer a kaleidoscopic view of how the law makes sense of and responds to the impact of climate change on public health. And so its chapters are arranged into 4 parts. The first sets out information about legal rights and public health impact that is basic to the rest. Also provides a technical and institutional overview by mapping connections between climate change and public health, exploring the challenges those connections pose to the public health sector's ability to carry out its core mission, and proposing several cross-cutting law, policy, and practice approaches that should help to inform any public health agency's responses to climate change. The book's second part considers several cross-cutting issues that arise both from public health impact, climate change, and responses to those impacts in key contexts. You can see how diverse they are, dealing with speech, surveillance, and the built environment. Again, this was an unwieldy thing that we tried to package into a coherent text. The third part of the book focuses on particular impacts and sectors where those impacts are felt. It also considers responses that they prompt or ought to prompt. And the final part, number 4, turns to the dynamic relationship between climate change, public health, and environmental law and regulation. First in the international context and then in the domestic one. Of course, it is impossible to cover this entire 14-chapter text in 20 minutes, so what I am going to do instead is just pick and choose and give you a sense of the range of issues treated in the book with 4 chapters that you see listed here. Starting with Chapter 2, which was written by my co-editor Mike, The Duty to Protect Public Health from Climate Change Impacts. Now, that chapter discusses more than just these 2 cases and then the sort of set of cases there in the 3rd bullet, but this set of 3 is, I think, a very good illustration of the core issues, and in particular the issues that you see here in the U.S. The first of those cases, DeShaney, was a Supreme Court decision in which the court held that, quote, as a general matter, a state's failure to protect an individual against private violence simply does not constitute a violation of the Due Process Clause. The court went on to explain that the Fifth Amendment's Due Process Clause, quote, cannot fairly be extended to impose an affirmative obligation on the state to to ensure that those interests do not come to harm through other means. Now, this rule, that there's no affirmative duty on the state, is subject to two limited exceptions. One is called the special relationship exception, and the other is the danger creation exception. In summary, in the U.S., the Constitution does not require a given level of public health protection except minimally for those who the government has taken into custody. There are other examples of those exceptions, but that's the big one. So the second bullet there, Juliana v. the U.S., this is a case that many of you have likely heard of. In this case, 21 youth plaintiffs filed a lawsuit in federal court against the U.S. government. They asked the court to compel the government to take action to reduce CO2 emissions consistent with key thresholds, so 2 degrees Celsius and 350 parts per million of carbon dioxide in the atmosphere by the year 2100. The plaintiffs claim that the nation's climate system is critical to their constitutional rights to life, liberty, and property, and that the federal government has violated their substantive due process rights by allowing fossil fuel production, consumption, and combustion at dangerous levels. So DeShaney allows for a danger creation exception to affirmative duties, meaning if a government has created a danger, then maybe it does have an affirmative duty to deal with the implications of that creation, of that danger. This case, Juliana, tests the limits of that exception. It alleges that the government has contributed in a material way to the creation of the climate crisis and to the public health threats and impacts individual plaintiffs such as asthma and psychological distress. Federal district court that heard the case found that the plaintiffs had pled a colorable claim, that a constitutional right to a stable climate system does exist, and it ordered, that is, the court ordered, that the case should move to trial. The subsequent procedural history has been very complex and has included repeated efforts to try to get the Supreme Court involved. It hasn't yet. The case has not yet gone to trial, and whether or not it will is a question that's now before the Ninth Circuit, so stay tuned. The third bullet, local governments versus fossil fuel companies, that covers a category of cases that have been brought since 2017. Since then, more than a dozen cities and counties in the U.S. have filed lawsuits against fossil fuel companies. The counties and cities seek compensation for the costs of adapting to climate change. And the cases claim that the defendants are liable for a range of torts, including public nuisance, failure to warn, and several others, as well as some statutory violations. The lawsuits all tell a common story. The fossil fuel industry knew the climate change was happening, that it was caused by fossil fuel production and consumption, but it hid that, lied about it, and paid other people to lie about it too. And therefore, say the plaintiffs, the defendants should pay for the resulting need to take hugely expensive adaptation measures. The cases are in different stages, and they're all at least a year and a half away from any kind of final decision or resolution. And in all cases, it's fair to say that the plaintiffs have a tough hill to climb. It's unclear that any one of them will necessarily prevail, but it is worth noting that regardless of the outcomes of their particular cases, they have already focused a lot of attention on the idea at the core of their argument, which is that these companies are to blame and should be held accountable. And so, to sum up the chapter, as my co-editor concludes, where there can be no question that there is a moral imperative, that is a moral imperative, for government and corporations to respond to climate change threats to public health, the extent of the legal duty to do so remains a very open question. The next of those 4 chapters I'm going to talk through deals with government speech and compelled disclosure. And more specifically, it tries to provide something of an answer to that question that appears in italics on the slide. Now, government has a great deal of discretion when issuing particular public health messages or allocating funding to promote those messages. So the First Amendment does impose some limits on what the government can require of prospective contractors. The more interesting question comes up in relation to compelled disclosures about climate-related risks. How far can the government go? Could the government require real estate sellers to inform prospective buyers that, quote, this building has not been assessed for vulnerability to floods using projections that take into account sea level rise? Could the government require consumer products to bear a label warning them that what they're about to buy was made using electricity from a coal-fired power plant and that coal contributes to global warming? It's a tricky legal question, and one that could cut in different directions in different courts, depending on whether individual judges determine whether a specific disclosure is factual or controversial. Those are the key terms. If it is a factual statement that is compelled, then under the Supreme Court's 1985 decision in Zauderer, that's one of the two cases listed there in the bullets, the challenger to the compelled speech must show that the disclosure is not reasonably related to a legitimate government interest. If it's a controversial statement, then under the 1980 decision in the Central Hudson case, it's the top bullet, the government must show that the restraint directly furthers the asserted state interest and does so in a narrowly tailored way. David Vladeck, who's a former chairman of the Federal Trade Commission and the author of this chapter, concludes that most government-compelled climate change disclosures would be upheld by courts. They would allow it. And that the government's power to require disclosure aimed at educating the public on issues relating to climate change gives the government a really powerful tool to amplify its voice and to reach a broad audience. In particular, Dave Vladeck proposes 4 government initiatives: emissions disclosure requirements for gas-powered consumer products, climate risk disclosure requirements for publicly traded companies, codification of climate disclosures in environmental reviews under the National Environmental Policy Act, and disclosure of government subsidies for fossil fuel companies. The proposals include important caveats, and taken together, they cannot fill the entirety of the climate change information gap, but they would represent an important set of steps to be taken right away. Next up, 3 of 4, for those of you who are flagging, we're on the back half, is another of the cross-cutting issue chapters. This is the chapter on the built environment. I wrote this one along with another colleague, Jenny Klein, and it really deals with 2 broad issues. They're noted there in the bullets. So climate change is the basic and underlying cause of a series of intermediate and ultimate effects. Many of these effects are made more or less severe by the built environment, meaning infrastructure, buildings, facilities. The urban heat island effect, which I expect many of you have heard of, is probably the best known example of this. Cities are full of dense, dark, impervious, inorganic surfaces, as well as vehicles, machinery, and facilities that generate heat. And for all those reasons, in hot weather, cities tend to heat up faster and to a greater degree in areas with fewer buildings and more trees. And cities also maintain thermal inertia. So even if the weather gets cooler overnight, built surfaces' re-radiation of heat into the ambient air keeps things warm. Dealing with the acute effects of heat on public health involves one set of solutions, things like cooling centers and check-ins on vulnerable individuals. Dealing with the urban heat island effect can reduce the number and extremity of those acute threats, but it tends to involve a set of solutions that require transforming the existing built environment, so the electric grid, roads, buildings, pavements, and that kind of transformation can really only proceed after navigating a long list of processes that tend to include design, financial, administrative, and legal steps. All that makes it difficult to act coherently and quickly, and to do so on the necessary scale. So all that might prompt you to ask, if we know about specific dangers of flooding or heat or other impacts, and we know what needs to be done to avoid letting them cause injury, shouldn't local governments that are capable of doing them be liable if they fail to do so? In other words, can't I sue the city that ignored a foreseeable risk? Of course, on the other side of that coin is the question, what legal risks do local governments run by going ahead with plans to adapt, if those plans might affect property values of some residents? So for answers to these questions, I'm going to refer you to the chapter rather than talk it all the way through. I'll say at this point that you should be prepared to be disappointed in what it is that you can compel a local government to do, and that local governments are generally phobic of getting sued over, well, a long list of things. The 4th chapter, and the last one that I'll inflict on you all, relates to public health information, or health information assessments, and incorporating public health into climate adaptation planning as a result. This chapter was written by Jessica Wentz. She highlights the importance of public health impacts and argues for their consistent and thorough consideration using a health impact assessment tool when undertaking climate-oriented policy development and implementation. Some quick background. There are a number of different types of public health considerations and impacts that are relevant to climate change mitigation and adaptation. These impacts can be positive or negative. Approaches to measuring health impacts associated with greenhouse gas emissions reductions generally fall into two buckets. One is measuring co-benefits, that is, not the direct effects of reducing greenhouse gas emissions, but the co-benefits of doing so, maybe reducing other pollutants like sulfur dioxide or nitrogen dioxide or other toxic pollutants like mercury. And the second bucket involves measuring long-term benefits of climate change being made less severe. It's generally done with a tool like the social cost of carbon, social cost of methane, or the social cost of nitrous oxide. I'm not going to pause to describe the nature of that tool. If anyone wants to talk it through, please pose a question during the Q&A. Another bucket, the health impacts of adaptation projects, is less well explored, but also extremely important to making informed choices. So on this slide, you see listed the few states that have adopted formally speaking, a requirement for HIA. And currently, legal frameworks supporting HIA are not limited to these. They're diverse, they're fragmentary, and they're all generally partial in their coverage. At the federal level, regulatory impact analysis and environmental impact assessments get some of the considerations at issue some of the time. At the state level, practice is extremely varied, and some states require thorough reviews, but most don't. At the local level, and with respect to individual facilities, review is also mixed, sometimes thorough, but more often partial or wholly absent. The list of 4 states here and the language of the laws that they have adopted indicates those few states that do have a health impact assessment requirement, but as you can see, there are few. And due to the lack of legal mandates at the state level, health impact assessment is usually conducted on an ad hoc and voluntary basis, often with funds or other forms of support from non-governmental actors rather than governments. In many instances, health impact assessment is conducted entirely by a non-governmental actor and then just submitted to a government agency as an input into the decision-making process that it pertains to. When undertaken voluntarily by a government, it is often due to public pressure to evaluate health impact in the context of the particular project. Some jurisdictions have provided technical and financial support for health impact assessments, even if they don't require them. That includes Oregon, where the Oregon Health Authority has published a guidebook, Climate and Health Impact Assessment, and California, which does require them, which has published its Health in All Policies Task Force has published Health in All Policies, a guide for state and local governments. One last slide about Jessica Wentz's chapter, the Health Impact Assessment chapter. Existing approaches sometimes unduly constrain the use of this tool, and resource constraints often limit its scope, depth, and quality. The ways in which they do so are listed here in the bullets. To address those challenges, the chapter recommends building on and improving existing frameworks and authority, not just by making health impact assessment part of decision-making, but also by streamlining review processes to make that additional aspect of regulatory processes practically feasible. Specifically, the chapter recommends 3 things. Legislative bodies can enact legislation or establish guidelines about how and when impact assessment should be conducted. Legislatures or agencies can expand the legal requirements for conducting independent health impact assessments, or, as Oregon has done, develop clear guidelines to include health impact assessments in existing planning and impact assessment processes. 3, more support can be provided for the development of methodologies for assessing climate-related public health outcomes and for sharing knowledge about those tools and means of assessment. Examples of this might include the social cost of carbon, which I mentioned. California's Department of Public Health has issued a health impact assessment on its cap and trade program. That's a useful model. The Climate Smart Communities Scenarios Health Impact Assessment was issued by Portland, Oregon, the city of Portland. That was used in its assessment of a low-carbon transportation and land use planning set of scenarios. And then I think this is the only non-state, non-local entity on the list, but the Southeast Florida Regional Climate Action Plan also issued a health impact assessment of mitigation measures that they undertook. The Southeast Florida Regional Climate Action folks are a unique result of the state of Florida really not wanting to deal with climate change and localities finding it a fraught issue, but something that they individually couldn't manage. So you have a compact of localities working together. And in this instance, they produced a useful document for everybody else. So I'm going to wrap up by describing several issues that we identified in the course of, well, other people helping us to write chapters in this book and also reviewing what they wrote. We discerned 4 foundational issues for future action on public health and climate change from the diverse topics that the book covered. Ultimately, of course, and this somewhat repeats, but we've only scratched the surface with this. And in fact, we hope that for the moment, it may be that we've written the book on these 3 things, but we really do want others to write other books that eclipse it. Having said that, I'm going to talk through those 4 bullets. First is policy silos. So people responsible for formulating or implementing policy of one sort often do so in ignorance of how their decisions will affect or could be improved by information gathered and analyses conducted by people responsible for an officially unrelated policy area. Odds are that everyone listening to this webinar is very familiar with this problem, so I'm not going to dwell on it too long. The second one, governance gaps. This one has to do with the fact law tends to emerge in response to past experience, usually of a problem or a conflict. And so novel problems or old problems that have cropped up on an unprecedented scale often go unaddressed legally, or they're addressed only indirectly or incidentally by existing law. We see this with climate change as a whole, but also with specific responses to things like disease surveillance, heat, sea level rise, and others. Next is institutional capacity. Because existing institutions are generally built to deal with past circumstances rather than present ones, problems of an unprecedented nature or scale can often exceed institutional capacities and are rarely, if ever, met, at least initially, with an adequate response. Public health impacts such as infectious disease and migration, and really adaptation efforts across the board, are examples of this phenomenon. And the fourth here, information costs. The costs of thoroughly examining policy options are often more readily apparent and immediately felt than the benefits of that kind of examination. This can be true even when the benefits are likely to include revelations so significant that they would sway the policy choice. We see this in relation to the analysis of regulatory health impact assessment, where policymakers often miss significant opportunities as a result of their bias against investments in more information. On the other hand, as discussed in relation to government or compulsory speech, it may be possible to address this sort of bias among individual citizens and institutional actors, at least in some instances. Ultimately, we do not have a comprehensive set of legal reforms for the public health sector that we recommend. Much work has been and still is being done at multiple scales, and the process, as I expect you all know, is very much underway. Our book is intended to help inform the process and to advance the conversation. And as I said, we are hopeful that others will pick it up and run from where we've left off. Thank you all for your attention. I look forward to questions and the discussion.
Well, thank you very much to Natasha and to Rob and to Justin for these excellent presentations, really compelling and informative. And we've gotten some Q&A, some questions coming in through the Q&A function. Those of you who haven't yet had a chance to submit them, please feel free to keep those questions coming in, and we'll go ahead and start with those that have come in so far. And I did also want to acknowledge, I neglected to do it at the top of the webinar, but I also wanted to thank network colleagues Betsy Lawton and Colleen Healy-Bufides for their work in recruiting this excellent set of presenters and working in the preparation phase for the webinar as well. So moving to our first question that we've received, it's a question for you, Rob, unless others want to weigh in as well. But the question is, last year, the Ho-Chunk Nation was the first tribal nation in the United States to amend their constitution and protect the rights of nature. So I suppose the first question is, presumably, are you familiar with this? And then from your policy perspective, how beneficial would it be for, other government entities, whether it be other tribal nations or states or local municipalities, to pass similar laws or constitutional amendments or resolutions. Rob, do you care to venture any thoughts or comments?
So that's a great question. I've actually been following the rights of nature movement since the early 90s when I first ran into it during my undergrad work. I watched in Pennsylvania when some local municipalities tried to enact rights of nature into their municipal codes to fight fracking, and that effort ultimately failed in the courts. But now with climate change, we're seeing more and more different entities trying to use rights of nature to help protect themselves. Besides the Ho-Chunk, there's also the Leech Lake Ojibwe, who passed legal rights for manumit, for wild rice. But that's a very evolving field, and I think it's a novel idea and one that would be a good thing to try, and I'm hopeful that maybe Justin has some perspective.
Thanks, Rob. Did you want to weigh in, Justin?
I think mostly no. I'm tempted to opine, but I'd say I don't know enough about the interactions between tribal law and the sorts of policies that it might run into that I could give you with confidence an answer about what levers this could move. Sorry.
Well, I'll throw another question your way, Justin. It was one I think that was directed at you that came in through the Q&A, and may have been prompted by events over the last few weeks. It was a question about bond rating disclosures, as we've seen some players, credit rating agencies like Moody's, essentially saying to cities and states that they will need to enhance their disclosures about both their risks and vulnerabilities relative to climate change, as well as their steps taken to address those risks. And so the question was simply whether there was any comment about that trend, about relative to bond rating disclosures.
Sure. So what I know of this is in part just the same articles that others might have seen, and in part from conversations at a workshop I attended last year that several folks actually from Moody's also attended. And so I had the chance to talk with them a bit about what it is that they are doing and are trying to do. They're not alone. The other rating agencies are similarly well aware of the huge relevance of climate change to the viability of certain municipalities and the impact of various things on municipalities' fiscal footing and frankly, their ability just to repay their debts over multiple decades. The issue is really one of how to, there are a lot of municipalities, and so how do you develop the right heuristics to accurately identify risks and then to assess whether or not municipalities are dealing effectively with the risks that they face. And so the news that I think that broke a couple weeks ago was about Moody's acquiring a firm that specializes in the analysis of climate-driven risks and some of the implications of those risks of a financial sort. It's unclear what exactly Moody's is going to do by virtue of that acquisition, but the acquisition itself was pretty unusual and is a strong signal that they're not just paying lip service to the recognition of manifest facts. They're going to try to figure out what to do. In terms of what that's going to mean, my guess is that you'll have some kind of adjustment made to decisions about municipal bond ratings. It could be a generic one. It could be specific to bonds issued for a particular project. I have guesses and speculation about the kinds of things that'll drive it. You can imagine localities that are coastal and that are located near a Superfund site might get a special asterisk. You can imagine localities that are seeing daytime flooding, sunny day flooding, basically floods not caused by storms or anything else, but just because sea level is rising, getting an asterisk. There are any number of risks that I can see causing Moody's to pause before saying, yeah, this bond issuance makes good sense. But I don't know more about specific legal implications, and the interaction of that kind of news and also a particular issuance and a decision about rating it might interact directly or indirectly with disputes over local adaptation laws. But as a general matter, I think you can take it as a strong indication that the financial community is going to encourage localities to more seriously consider adaptation, partly just for fiscal reasons.
Thanks, Justin. Really, really helpful. And the next question is for Natasha. And it's, I think, maybe growing out of the end of your comments and someone asking you to expand more on the role of partnerships in NEHA's, or NEHA's role in partnerships with respect to climate and health.
Thank you for that question. Partnerships have been a great way of how we've been able to strategically move forward in the space of climate change and health and be able to strongly make a difference. And we have individually, NEHA has partnerships with CDC. CDC is funding some of our climate and health work through their climate and health program and the National Center for Environmental Health. Historically, we have partnered with Eco America, and I shared with you a lot about that working relationship. But with Eco America, we actually sit on their Climate for Health Leadership Circle. That gives us access to many additional partners with which to collaborate. So that's a partnership that has driven even further partnership in the space. And in addition, we have some more informal partners that we have worked with. We like to work across the aisles. I'm preaching to the choir in the field of public health. Working outside of your sector is very helpful. And so we have strong relationships with planners, public health planners, and urban planners. And the expertise that we bring to the table and that they bring to the table makes a stronger and more beneficial relationship. And we also work with nurses, the Alliance of Nurses for Healthy Environments, and many in different fields across public health and even beyond public health. In many cases, we bring the environmental health voice to the table and expand with our expertise. And then we also have some partnerships among others that are all speaking the same language. So I appreciate the question on partnerships. I actually work in the Department for Program and Partnership Development. So we find strategic partnership engagement to be important on all fronts of environmental health, especially in climate change and health. Thank you.
Thanks, Natasha. And now a question for Rob. Rob, can you expand on how climate change could limit the ability of the Ojibwe people to exercise their treaty rights?
Sure. So there's a legal reason, and then there's also a functional reason. Functionally, some of the species or beings upon which they depend for subsistence, hunting, and fishing and gathering, as a response to climate change, could move out of reservation and ceded territory areas. And those rights that they reserved for themselves in the treaties are specific to, if you noticed the map at the beginning of my presentation, specific to those areas in Minnesota, Wisconsin, and Michigan that were covered by the treaties. So should, for example, wild rice, which is at the southern end of its range, become extirpated in the ceded territories and only be available, say, in northern Minnesota or in Canada, our tribes here would not be able to rely on their treaty rights to go elsewhere to harvest.
Right. Okay. Thank you, Rob. And then a question for Justin. Justin, are there any lawsuits out there that you expect will spur big policy changes?
Well, I mean, arguably the lawsuits that pushed BG&E into bankruptcy already did. So there was, obviously those lawsuits were possible as a result of a particular nature or the particular character of how the California Constitution had been interpreted. But that's, I would say, the leading example of the operation of the traditional legal system having big policy effects in response to some signal that adaptation is required. An example, I guess, it's probably more in line with your question, is a lawsuit that was brought by the Conservation Law Foundation against Exxon. There are two of these. One's in Massachusetts, just north of Boston, the other's in Rhode Island, and they both relate to the issue of whether or not fossil fuel companies have complied with their Clean Water Act permits for facilities that are on coastlines. The basic idea is to look at the permit with a somewhat naive understanding of how the Clean Water Act works and say, well, if I read the language and it says this company needs to take appropriate measures to deal with known risks, then they need to take climate change into account, and the way that the facilities are currently arranged and protected against potential large-scale precipitation or a storm or a flood simply doesn't suffice. And so what could happen in those cases is you could see a different interpretation than what has gone before of the Clean Water Act, and one that would basically compel companies with coastal facilities to take potential climate-driven risk into account when designing and operating those facilities. Now, it bears noting that initial phases of this case involved judges more or less saying, I really don't want. Actually, I think there's a quote from Judge Wolf in Massachusetts saying something like, I don't want this to turn into the Scopes monkey trial of the 21st century. They are really eager not to make this a trial about climate change per se. So I'm not sure what exactly that will mean, but that, I think, is going to potentially be a very meaningful decision one way or another, because it will tell companies about the kinds of risks that they face from potential lawsuits under existing law, so you wouldn't need to pass new law. So that could be effectively a policy change from courts. I don't want to talk too long. I've got others that I can throw at you, but I'll pause there.
Well, yes, any one of these questions I think we could talk at some great length on. But I do have one question here that I'd be interested to hear all of the presenters' thoughts on, and it's really a question, I think, about jurisdictional level of action. So the question says, and I think we can see if any. Why don't we do this? We'll go in the order of people having spoken. So Natasha, I'll say the question and turn it over to you first if you have any comments, and then we'll go to Rob and Justin if they have things to add. The question is this: given the current national political climate and the difficulty of addressing climate change at the federal level in the U.S. Congress, do you think that it makes greater sense for activists to advocate for local and state and tribal policies that offer preventive measures and remediation for the effects of climate change? So again, turning it over to you first, Natasha, just any comment on sort of where it might make sense for people to concentrate their efforts, if you have any thoughts in that regard, federal, state, local, tribal.
And so thank you for this question, and it's a really important question to ponder given the current state of affairs. NEHA, we consistently share that climate change is inherently local. Though its impacts are worldwide, we are experiencing different impacts based on what region and even smaller than that, what locality we live in. And so we do urge local action, certainly local action to protect health. I'm not sure how wide this mantra is, but a lot of the thought is to think global but act local, and begin where you are, especially since the impacts are so different across different regions. So we certainly encourage that. There's evidence that supports that, and I certainly encourage you to view the National Climate Assessment that was released in 2018, the fourth iteration. It has regional chapters that show the regional differences as it pertains to the impact of climate change, and even explore some of those different health impacts regionally as well.
Thanks very much, Natasha. And Rob, anything you'd care to add?
Sure. I have two comments. The first is climate mitigation, the reduction of carbon going into the atmosphere, is a global issue. So it needs to be done at national scale. Adaptation, however, is a local issue, because all adaptation is going to be local. It's always going to be adapting to what's right there in the place that you are. The other thing I will note is that we recently, along with I think every tribal government in the United States, got a request for information from the Senate Indian Affairs Committee and the Special Committee on the Climate Crisis to provide information on things like policy and regulation, changes that could be done at the federal level to assist tribal nations with climate mitigation and adaptation. And while I think there's limited chance of anything happening right now, I think these senators are being proactive and concentrating all efforts on state and local is dangerous, because it lets the feds kind of off the hook.
I appreciate that caution, Rob. And Justin, is there anything left to say on this question? What would you like to add?
I would just add that I think the answer depends on what you're shooting at. Certainly in general right now, it's hard to play offense at the federal level. There is a lot of defense to be played, and you can play it more or less effectively, and it can matter quite a lot. But state levels, or state and local level right now is where you're going to see progress made rather than just ground lost. After the upcoming election, it's unclear. It'll depend on the composition of the Senate and whatever it is that is adopted by the executive that's incoming. As a general matter, I would say whatever the federal government does, it's going to establish a floor and maybe remove limits, but fundamentally, the action that you're going to see, and this tweaks what Rob said a little bit, both on adaptation and to some degree on mitigation, is necessarily going to involve action on the part of states and localities. And so I think he's right to say that the global nature of climate change means that you need a federal actor on the mitigation side, on the side that deals with emissions, but the only way it's going to actually happen is necessarily going to involve action on the part of states. And so the leadership that you're currently seeing in the absence of federal role, I don't think is necessarily going to change, even if the federal government warms to the idea of climate action. I think you're still going to need states pushing ahead and experimenting in ways that establish models that others can then pick up. So this is I guess my effort to bless all people who would prefer to deal with the state level. But I think that can well continue, regardless of who's in charge at the federal level. Well,
thank you to all three of our panelists. I think maybe we could sum up the answer to that last question from our three presenters is start somewhere and get busy and stay busy and keep at it. Well, this has been a terrific discussion. I really appreciate our presenters. Thank you to our presenters. Thank you to all the attendees and especially those who submitted questions. And I'm going to hand things back over to Allie Charles who has some closing information to share as well.
Thank you, Jill. And again, thank you everyone for your participation in today's webinar. And thank you again to our panelists for presenting today. I learned a lot, and I know our attendees did as well. So just a few final notes to all of our attendees. You will be receiving an email from the network with a video playback of this webinar, as well as a link to our very brief webinar survey. It takes just a minute to fill out, and it provides us with some great information and feedback, especially in regards to what topics you might be interested in for future webinars. You'll also be receiving an email from ASLME with information on how to apply for CLE credits for this event. Finally, be sure to check out our upcoming Public Health Law Summit, focused on data sharing and community health this October. You can learn more about the summit and other upcoming events by visiting the events page on the network's website. That concludes today's webinar, so thank you all for attending and have a great rest of your day.